Most people think estate planning is one-dimensional. I need a will. From there, the question inevitably goes to, well, do I need a will or do I need a trust? And while that's an important question, it's also missing half of the estate planning picture. I've got two scenarios that show when you need a trust and when you don't, plus the estate planning gap that could leave your family in a really tough spot. I've got that and more coming up. Estate planning is one of those areas where a little bit of knowledge can go a long way. And yet it's also one of the most overlooked pieces of a comprehensive financial plan. Over the years, we've helped hundreds of people, maybe thousands, get this right. And we've seen what happens when you don't. So let's get into it. Starting with the basics between a will and a trust. A will and a trust, they're both legal documents that direct what happens to your assets when you pass away. But they work very differently. A will goes through probate. That's the court-supervised process of distributing your estate, all your assets. It's public record, can take months to complete, and it can be very, very costly. A trust, on the other hand, is a legal entity that holds your assets during your lifetime and transfers them directly to your beneficiaries when you pass away. There's no court process, there's no probate, there's no delay. So which one's right for you? The honest answer, the obvious answer is it's going to depend on your situation. And I want to walk through two real-life scenarios that show what it looks like in practice. Scenario number one, Carol is 63 years old. She's a widow. She owns her own house. It's paid off, though, and worth maybe $500,000. She's got some retirement accounts and some other investments, but also a cabin up north that's been in the family for a few years. She's got 3 adult kids, and here are the wrinkles. One of her kids has a complicated marriage. Carol's biggest concern is that if she passes away, her assets could end up in the wrong hands. She wants her kids to inherit what she's built, not have it potentially wind up to an ex-daughter-in-law. For Carol, a revocable living trust makes a lot of sense. Here's why. First, she owns property in 2 different states, the house here in Indiana and then the cabin up north in Michigan. Without a trust, those assets are going to go through probate, but not just one probate, 2 of them. One in Indiana and another in Michigan. That creates a lot of cost, both financially, but also the cost of time and complexity, the travel. The second reason, with a trust, Carol can set up conditions on how and when assets are distributed. She can build in protections and name a trustee that she trusts, maybe her oldest child or a professional trustee, and she can manage things according to her wishes. And then third, this one people miss a lot, because Carol's estate is large and spread across multiple assets, a trust gives her a lot of control and flexibility and privacy. A will is a public document. Anyone can look it up when you're gone, whereas a trust is private, which is another reason why a trust is the right tool for Carol. Now, scenario number 2. Dave and Linda, they're a married couple in their 50s together. They've got retirement accounts. Most of their wealth is built up there in 401ks and IRAs and a Roth IRA. They also have a little bit of money in a checking account, savings account. They own their home jointly, and they've got 2 adult kids, both financially responsible, no real complicated situations there. And their estate, when you add it all up, it's in pretty simple and good shape. Nothing extraordinary, large, or complex. And therefore, for Dave and Linda, a well-drafted will combined with proper beneficiary designations is really all they need. And here's why. Most of their assets are in their retirement accounts, their 401k, their IRA, their Roth IRA, and those accounts already will transfer automatically based on the beneficiaries that they've designated. They pass to each other or directly to the kids based on the beneficiaries that they've listed on those accounts. Those assets are never going to go through probate, regardless, as long as they've got those proper beneficiaries. The will handles the rest, which in their case would be the house and the cars, maybe a bank account. Because their situation is relatively straightforward, the cost and complexity of having a trust may not be worth it. Now, once you answer that question, whether a will or a revocable living trust is the right approach for you, you can't stop there. That's not enough. Many people think that a full estate plan is just getting a will in place or maybe a trust in place. It's not enough. Because a will or a trust, those documents only direct what happens to your assets when you pass away. But what happens when you don't pass away, but you can't speak for yourself? You can't manage your own affairs. What if you're in a hospital or incapacitated and you can't make critical decisions and at that critical time? What if you've had a stroke or a serious accident and you're dealing with a medical emergency and you physically cannot make decisions? This is where the rest of your estate plan needs to step in. And if you only have a will or a trust, you've got an enormous gap. So what else rounds out a proper estate plan? Document number 2 behind the will is the durable power of attorney. This is the document that authorizes someone that you trust, so your spouse, a child, maybe a close friend, to make financial decisions on your behalf if you can't. So paying your bills, maybe managing bank accounts, filing your taxes, making some investment decisions. Without a financial or durable power of attorney, if something happens to you, your family may have to go to court to get the legal authority to do these things for you. Even your spouse may not automatically have the authority in every situation. That process, it's called a guardianship or conservatorship, depending on your state. It's expensive and slow and emotionally draining. And it's completely avoidable by getting this financial or durable power of attorney set up. Document number 3 behind the will and durable power of attorney is the healthcare power of attorney or healthcare power of appointment. It's a similar concept, but this one covers medical decisions. You're naming someone that could speak for you if you cannot speak for yourself with key medical decisions like, do you need this surgery? What treatment option should you be transferred from one facility to another? Without this document, healthcare providers may default to a hierarchy set up by state law, and the person that they turn to may not be the person you would have chosen. Or worse, maybe your family members disagree and there's no authorizing structure to that. The healthcare power of attorney removes all of that uncertainty and lists the individuals that you want to make those key decisions. And then the final document is a living will. It's also called an advanced medical directive. Now, this is not an official legal document, but it's part of the cluster because this one is where you write down your own end-of-life wishes. If you're ever in a situation where you can't communicate some of those end-of-life decisions. This is not a do not resuscitate, but it's things like extending life support beyond what doctors believe is appropriate, right? Those sorts of things. A living will answers those questions before the question needs to be asked and takes the burden of those just gut-wrenching decisions off of your family. Guys, I cannot tell you how many times we've sat across the table from a client who's smart, financially prepared. They've done a lot of saving. They've got a great retirement plan in place. And when you get to the estate planning piece and ask about these documents, they just have a blank stare and come to find out it's one of the financial issues that keeps them up at night, that they don't have the right plan in place and have these lingering questions and concerns. Having a well-rounded estate plan is not optional, and it's not just for the elderly. These are for anyone who has assets or life insurance and people in their life who they love and who love them. So here's the big picture. Estate planning, this is one of the 6 areas of your financial life, and it doesn't exist in isolation. Your estate plan connects to your retirement plan because how your assets are titled and how the beneficiaries are set up, that is key. It connects to your tax plan because the structure of a trust can have real tax implications. Of course, it connects to your protection planning, listing out beneficiaries on your life insurance, and that impacts your estate as well. This is why it's critical that you take a comprehensive approach to your financial life. We call it one plan, and the estate planning piece isn't just about what happens when you die. It's about making sure that at every stage of life, your wishes are protected and your family is taken care of. All of it working together. That's comprehensive financial planning, clarity, confidence, and creativity. Work with your certified financial planner on that. If you don't have a CFP on your team, you can contact one on my team. Find us online, Korhorn.com. That's Korhorn with K, wisemoneyshow.com. You can find us there as well, or give us a call, 574-247-5898. All right, there you have it. Go out and take your next wise step in your financial life.